Welcome to Law of the Weird. My name is Tom Swanson, attorney at law, Houston, Texas. Today I bring you some weirdness from an appeal court case in the Texas State Court of Appeals in San Antonio from 1995. And it arises out of a case called Peak versus Equipment Services, Inc. Essentially, it is a wrongful death case where family members are seeking benefits due to the wrongful death of a family member. In this case, one Mr. DeBerry, who worked for Equipment Services, Inc., his duties included providing service to another company, Browning Ferris. And at any rate, Mr. DeBerry became delusional and became convinced that a Mr. Peak, who worked for Browning Ferris, was part of the mafia and was conspiring to do harm to Mr. DeBerry and his family. And a number of people at Equipment Services, Inc. were aware of the fact that Mr. DeBerry had some history of mental problems, and that he had voiced his belief that Mr. Peak of Browning Ferris, a customer of Equipment Services, was really part of the mafia and was going to do great harm to Mr. DeBerry and or his family. And so, at any rate, nothing was really done about it. I guess they didn't take it seriously because even though they knew Mr. DeBerry had mental problems, he had never engaged in any violent activities. Well, this all came to a head in 1984 when Mr. DeBerry shot Mr. Peak dead based upon his delusion, apparently. This led to a lawsuit by the family against Equipment Services, the family of Mr. Peak. They sued Equipment Services. And basically what happened was the Peak family lost their case. And the reason that they lost was, and they lost without a trial, the reason they lost was because of a general rule that an employer is not liable for an employee's negligence or misconduct unless it arises out of the work. In other words, it must be in the course and scope of employment. And obviously, shooting your customers dead, the court found, did not arise out of the course and scope of employment. Therefore, they affirmed the trial court, they upheld the trial court in determining that the Peak family could not recover against Equipment Services, Inc. So, as I say, just because you're paranoid doesn't mean people aren't out to get you. And I would recommend any employer to warn a potential victim of somebody who had a mental fixation on them and might cause them harm. Some action, it would seem, should be taken, but in this case, the notion of respondeat superior liability or liability of the employer to warn, these things were not considered a legal responsibility of Equipment Services, Inc. At any rate, I read this case and thought, Jesus Christ alive. I mean, can you imagine? Here you are, you're just a guy working and one of your vendors, employees comes in and, who had contended that you were a member of the mafia and shoots your ass dead as a doornail. I don't know what to think about it, but it sure is weird. Just remember, you can, when you hear about these cases, you can sit there, look in the mirror and say, you know what, I always knew I was normal. Now I've got some confirmation. This is Peak versus Equipment Services, Inc. It's a 1995 decision out of the San Antonio Court of Appeals. It is found at volume 906 of the Southwestern Reporter, beginning at page 529. Thank you, and I'll bring you something weird down the road. Take care. Tom Swanson.